saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court's own rulings and say, on this we disagree. What is happening here? Because somebody has supermajority? What is happening in this country?
Honorable Minority Leader,
what have we done wrong?
I will not have a problem.
I have not attacked any judge. We've not attacked the court.
This is by way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what.
So
that's
let's
exactly
stick
what is
to
being
the
done.
rules.
I don't
and
have
then
a
you
problem.
make your preliminary comment
right.
as such.
Very well, Chairman. Thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected, learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba Tokono. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy. A strategy to ensure that these cases languish undefended, creating space for this rash confirmation to proceed unchallenged. Why?
To be off. Yes, Honorable Ayariga, let me hear you.
Why? No,
Chairman. Chairman. I know now and then the minority leader will say that we are politicians and we should be allowed to do politics. Yes, we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution. And he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear that any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair.
Honorable Minority Leader.
I'm a member.
Please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader, you have the floor.
Seal that to me. But he's still there to me.
Mr. Chairman, some of my, yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure, but
I can be guided by the rules that enable the speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised, yes, Honorable Anymedu, let me hear you.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on became a member of this house. Every committee meeting, people, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise a question about what I heard other people say that, well, there had been issues, nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part, we have been here all day. The nominee had not even spoken a word.
Honorable,
this objection, that objection, and
Honorable
and yet we are getting nowhere.
You raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
It's not in response? Wow. Wow. Chairman, thank you. Oh, very well. Chairman, there nowhere in my submission did I impugn improper motives, or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that.
Leader,
no, Chair, he was just talking.
Just address the chair.
No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the ranking is doing is not right. You were given 5 minutes. We spent 15 minutes.
You don't have the floor. Honorable Dapamakpo, you don't have the floor. Honorable Roxanne Nelson Dapamakpo, you do not have the floor. You don't have the floor.
We've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG requested, applied to the court for leave to file out of time. It is a statement of fact. We are not saying anything apart from what is in the public domain. So, Mr. Chairman, the majority leader must be restrained. All the confusion is being caused by him. All the confusion, I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader,
Chairman.
with all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record.
Chairman,
Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman.
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where they will come, force you, speak, put on a mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very
Chairman,
loud and clear. If you disagree with it, you know what to do.
Very
Will you
well.
proceed?
Don't worry. Don't worry. We are all aware of what this whole thing is leading to. So no problem. Chairman, we, the minority, hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokono. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously. Same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither Parliament's ally in political projects. It is a guardian of our Constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
Woman, comport yourself.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give rights to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much indeed.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Should I respond?
The report is not ready to be voted for. We are not at a stage of approval. So your conclusion is very preemptive.
No, Chairman, let me
It's
Chairman would respect. Chairman would
this is not what I want you to respond to.
No, Chairman,
so
but
I don't want your
Chairman,
response on this.
To the extent that you've raised it, I just need to. I just need to.
Honorable
Chairman,
Minority Leader,
Chairman,
you have your day.
Chairman,
You have
What
your day.
we have-
The
we
two
have-
microphones should be off.
Chairman, we
The two
we have-
microphones should be off, with all due respect.
we have registered our position.
Honorable
and it is
Minority
very clear
Leader,
that we have
yes,
rejected. We don't need to vet him
agreed on
before
your position.
we reject him. And we
We
voted
agreed
against
on
him.
your
It's as simple as
positions,
that.
yes. When it is time for voting, then you can vote against the nominee. Yes, yes. So we thank you very much, and we wish you a very good luck. Honourable members.
Why you wish us a good luck?
Yes, sir. Yeah, okay. Yes. Honourable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. Be calm and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Please, before I answer the question, may I be expected to, may I be allowed to read a brief, make a brief opening remarks?
Allowed, you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of June 2008. So 17 years plus, I've been a Supreme Court judge. Before the 11th of June, for 2 years, I was a justice of the Court of Appeal. Before then, I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Korongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. as a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekondi, 1 year in Sekondi, and 4 years in Kejetia chambers in Kumasi, where I practiced with my friend, the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988, and I underwent 6 months military training, and I was posted to Sekondi. That's where I met my wife. At the time I met my wife, he was also a Bob No rank person. She didn't have any rank, actually. A sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Duyaya Nkwanta as a circuit court judge, brought to Kumasi. For 7 years, I was circuit court judge, and I became high court.
Remark. We've also seen you briefly describe the personal values.
Honorable Chairman, it is a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered, but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our higher. Throughout my career, from prison service through the Internal Revenue Service and the Judicial Service, where I've been for the past 33 years, I have integrity. I've believed that everything that I've done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody. And that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with. That this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamekbo to ask questions. Honorable member, you are entitled to 3 questions. You may ask up to 3 questions.
Chairman, thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually will be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that is on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years, meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rollins. Then I was promoted in 2000, and I was sworn in together with Secretary Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rollins, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my Lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you consider introducing?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost, it was 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was no need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions were, and so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition that was between Al Gore and Bush in 2000, the election petition, whatever it was, ended with the declaration of the new president before the inauguration. So at any elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that is granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, Court Management Conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be, and before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the lone ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
Yes.
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated.
Honorable member, I think
finish.
you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dapamakpo, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovelace Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidia. I used to appear before her. So that was, and so, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. In fact, they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with a career magistrate, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu.
Thank you.
You are entitled to 3 questions, strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents. But the legal aid remains in the doldrums. It is true that cost of litigation is now very high. And it's become very, very high, higher as a result of the delays that are occasioned in the courts. So that even small, minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of and then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to resolve the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Yarega, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have,
we want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. it's now left with time. Maybe we will get to a 24-hour. I'm certain the president stole his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
Very well. That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. I mean, previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working, or it has been suspended. Would you consider we'll have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended, no. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, residents there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidia, if the 5-member go, it's the same thing, around 40,000 cities. But you see, going from here to Koforidia is so easy, even though it is risky and inconvenient. It is still short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Sekedi again. We do virtual hearing of appeals for Sekedi. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidia. So even if the lawyers in the case are in Accra, they still have to go to Sekedi to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Kofodia and Ho. We are trying to get to a situation where lawyers will not go from Kofodia Ho to Koforidia, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in, some one of the parties could be in Koforidia, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my Lord is getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my Lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people, suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the things that we have fed it with. But, and I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring the 6th person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu. your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper, and so I'll be very, very happy if somebody came and, Daddy, I saw your picture somewhere. I mean, I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and two more cases are added. Then we have situations which I will refer to as, institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, that was LN 140 of 1948 or 1950, 1960, 1954, LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for his security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clogged, what we can do is that we should be able to track. Now we have a monitoring team, which I'm going to reinforce, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we could grant adjournments on the ground of somebody's wife, and because a lawyer says, my wife is being taken to the hospital. The judge asked us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. You have to come to court. And that is their system. But here, sometimes you have somebody coming to say, my father has died. 3 years later, he's asking for adjournment, and his father has died. 4 years later, the same father has died. How many fathers you have, you cannot really tell. So we see there's a human element to this. But we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice, and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean unlike it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Wa. I went to the best secondary school in Ghana, Koronguduma Secondary School. Somebody went to one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it is a girls' school. Achimamai Secondary School has now become a Fiakobi Girls' Secondary School. So he doesn't even know whether he's an old student or... So...
My Lord, he's still an old student. And the school is still in existence.
And then there is this Wa man who went to school at Goforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovelace Johnson, started from grade 2. Sergio Jamefe started from the Regional Tribunal. So both below the Circuit Court where I started. And then there were some of us who joined at the Court of Appeal, like I said, Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulenis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensa Bosu. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. It shows that once we come from different backgrounds, we will have different approaches to things. It could be our strength but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this. And you should be able to discuss things formally and informally before things escalate. You should be able to do things. Even empaneling can create problems among you. When somebody feels that this man is not being empaneled, I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice, I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Dorothy Kulendi, Justice Poaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frumpong was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Haji Aladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So that such cases would be handled or fast-tracked. Thank you.
Yes, my lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851. As of today, they are 3,562. A variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, they are 1,727. And this is replicated all over. The prisons are choked. And it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the Justice for All back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he has not been tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. the main condition a judge looks at is this man I'm releasing on bail. Is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum. He's trying to run away already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant you bail, it doesn't matter the offense that the person has committed. The judge may not grant bail. But even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, these old ladies, how when they harvest a particular plantain that he has nurtured over the year, my mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Kwankwanuase, playing drafts. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say, the man stole only a bunch of plantains. Do you know what it means what the bunch of plantain means to my mother? It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Insawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, around the courts, that they'll see me. Because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced. But that one is in your bosom. It's a law that one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, you know, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted paroles may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you send to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. You mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal court. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way money have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances?
Yes.
Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week we have. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible having 5 judges stationed at Tamale to take care of the North. This is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have find ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi, and they will be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Ade. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected.
Thank you.
And to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.